Okay. The matter before the court is Capital City Renewables versus Lily Peel, Waldo 24290. Council appear to be present. I'm assuming you're ready to proceed. First, can we begin by introducing yourselves, by saying your names for the record, together with the party you represent?
Good morning. Chris McLean from Camden, representing Capital City Renewables, Your Honor.
Good morning. Tyler Smith, representing Lily Peel.
Thank you. We are being streamed, I believe, live on the web, both by audio and video. Attorney McLean, if you'd like to proceed, we'd be happy to hear your argument.
Good morning, Your Honor, and may it please the court. In today's world, so much of our personal lives is contained in our emails. It's not just our personal lives, but it's our work lives, our financial information. Everything is in our emails, and we all know that. In this case, my client had an employee who he asked to maintain the confidentiality of information contained in those emails. And he made sure she understood that.
The green light is on,
Yes,
so
it is,
I'm
Your
going to ask you a hypothetical. Hypothetical means it's not this case, but it's got some different facts that I'd like you to respond to.
Those are difficult kinds of questions for me. But
So assume that she has not said anything. The family matter begins. Child support and finances become relevant. Your client files a financial statement that doesn't include the $440,000. If she then told the ex-wife about the $440,000, are you saying she could be sued?
I am, because I think there are a couple of different elements of the damages that we're claiming here. And one, of course, is the impact on the motion to modify, and that's, I think, what you're getting at. The other is just the emotional distress and really the damages to both my client personally, Mr. Lozanoff, and also to his company, CCR.
Do you have a reasonable expectation of privacy to hide your assets from the court?
You have a reasonable expectation of privacy in your private emails. And I recognize that we do have a duty of candor to the court regarding our finances. I think there's a lot more to that story that maybe we can get into. I'm not really sure how much of the money he received was income for IRS purposes.
Well, whether it was or wasn't, it would have had to have been disclosed inevitably in discovery.
Probably that's true, although whether it relates to income for child support purposes or not, I think is a separate, distinct question.
Can I ask you about
How private were these emails? How private were these emails? Were there other recipients of these emails?
I mean, clearly, the defendant has raised that issue, but I don't think that's a serious issue logically or intellectually, Your Honor, because virtually all private confidential emails are going to have a number of people. They might be copied to other attorneys that are representing you. They might be copied to experts who are representing you.
But isn't the basic problem that he actually did give her access to the emails? In other words, when you talk about intrusion on seclusion or invasion of privacy, the presumption is that somebody is invading whether it's a house or whether it's an email, without permission, that they weren't supposed to be there. Regardless of whether she should have disseminated it, he gave her permission to see these emails.
Sure. He gave her permission to see CCR emails. He explicitly prohibited her from seeing other emails.
But aren't the facts, at least based on the record in this matter, it's not clear that she could discern who the emails were from before she actually opened the emails. Isn't that true?
The court found that below, Your Honor, but that's not what the record reflects. The record reflects that my client testified under oath, Mr. Lozanoff testified under oath, that you could see which email was which. And the court found that that wasn't good enough for summary judgment purposes because there was no other corroborating evidence to support what he testified to under oath. But that's not the standard on summary judgment. On summary judgment, we have to take the evidence in the light most favorable to the non-moving party And we have to draw reasonable inferences from that evidence in the favor of the non-moving party. So in this case, there was clearly record evidence that you could discern the difference between a CCR email and any other email. So that's, so I don't agree with that proposition.
In Nelson, we said that the intrusion has to be, quote, an actual invasion of something secret, secluded, or private pertaining to the plaintiff. There were other recipients on these emails. So how could we conclude that this was private to Mr. Lozana?
The other recipients were my client's business partners and other people affiliated with in the zone of confidentiality. So it's, their emails, they're confidential emails among a circle of confidants. They're not emails that are to be shared with my client's ex-wife, who has no affiliation with the business.
You have a count in there for conversion. Just wanted to ask you about that. In this instance here, was your client ever prevented from having possession of these emails?
That gets to some of the debates. We have a transitioning technological world that we live in. And I kind of want to harken back, because I think the answer relates to another question here, is how do we distinguish between a private email or not? And I think the analogy is the employee had access to my client's physical office, but there were certain drawers in a desk that were off limits to her.
I think we get all that, but is there some reason why he couldn't have his email?
In other words, the fact that she sees it doesn't mean he can't see it and use it also, and isn't that the essence of conversion?
I think that I understand that sort of physical logic. Is it tied to an email server? Is that a physical object? It's really hard to frame.
I don't think the question is physical object. Even if we assume that one could convert an email, isn't the essence of conversion that you are wrongfully dispossessed? In other words, it's not that she could see it, but that he can't see it, use it. In other words, if she erased it, maybe that, but that's not what happened here. He had access to it the whole time.
He lost control of the confidential information, and the confidential information seeped out into the world, in this case to his ex-wife, and that caused
But the essence of
damages.
conversion is not that somebody else can access it, it's that he does not have access.
He lost access to the confidentiality of that information.
But
But he
when we
didn't lose
look at the
access.
case, when we look at the case law that extends this to emails, it's when someone floods a computer system, and so it slows down the computer system. There's a physical slowing down and interference in that way, while yours isn't in that same category, is it?
Well, I'm not a computer expert. I'm not 100% sure of the analogy you're making there, but there are several different ways that we tried to frame the legal argument here. And we can point to whether conversion is the right way to frame it, whether it's intrusion upon seclusion is the right way to phrase it. Is it a trespass to chattels?
Well, let's do the breach of contract one. How is this not a statute of frauds problem when in his deposition he said that the agreement was that she, quote, never tell anybody?
Well, as we pointed out, statute of frauds is an affirmative defense, and there's no record evidence supporting facts that would sustain a summary judgment order on that theory. At trial, maybe that's an issue that's going to get raised.
Isn't that the fact that he said she was supposed to never disclose it? Doesn't that take it out of the 1 year right there by his own testimony?
Well, I think that as it's an affirmative defense on summary judgment, and we have to understand the procedural posture of this case, the moving party has the burden of coming forward with evidence to support an affirmative defense.
Well,
And-
what is different about this term of employment, the breach of contract claim? What is different about telling this employee not to do something, not to disseminate these emails, not to look at these emails, than any other employment situation where you say to an employee, I want you to do this, or I don't want you to do that? Can every employee be sued for breach of contract every time they do something different than what the employer suggests they should do?
Well, I mean, I think if there's a bargain involved, an offer and acceptance.
Well, what's the bargain and what's the exchange of a consideration here?
Well, she came to him and said she needed access to emails.
To do her job.
To do her job. And he granted access on conditions, limiting conditions. And she breached those limiting conditions and caused damages. And that seems to satisfy the elements of contract.
And the consideration was what?
Her maintaining her job.
Can we take a walk through your last tort here? Just talk briefly, presumably about trespass to chattels.
Yes, sir.
2 questions. The first is, are emails chattels?
They never have been historically, but we have.
Are you asking us to declare that they are?
We have, yes, I am. We haven't.
But traditionally, they've been tangible items of personal property.
I think that we have to accept that our notions of intellectual property are evolving, and we live in a data-driven society where a lot of our rules and prior interpretations of these causes of action are no longer applicable.
Isn't that a slippery slope, though, when we start embracing concepts, that don't really, property that doesn't exist in the physical world? We're opening up a whole new Pandora's box there.
The history of our common law is the history of embracing new realities in the world we live in.
If we did embrace it, do you still hit all the bases there, that she disposes of the chattel, or that it's impaired, the chattel is imposed to its condition, quality, or value, or that he was deprived of the use of it, or that bodily harm was caused? Do we hit any of those bases?
Yeah, he's deprived of the use of it because the use of it presupposes maintaining the confidentiality of it. And when intellectual...
Well, that doesn't really interfere with his use of it. I mean, and that's part of the problem that you have from a causation standpoint, with respect to the chattels issue, with respect to the intrusion into seclusion, his seclusion. It's not... You're seeking damages that aren't related to the cause of action that you've put before the court. The damage that he suffered is as a result of the publication, arguably, but that's not those aren't the causes of action that you put before the court for which you can recover.
Well, as I pointed out in our brief, the issue of causation and proximate cause and damages is generally left to a trier of fact, the jury, and is not generally...
Well, there still
appropriate
has to
for
be
some-
evidence supporting it, but can I move to another, just more, a little bit, almost more technical? Peel was an employee of CCR, correct?
Excuse me?
She was an employee of CCR,
Yes.
not of Lozanov. He was also an employee and partner in CCR, correct?
Not a partner. She
Or
was an employee. Yes.
shareholder.
No, she wasn't a shareholder.
Oh, he wasn't? So employee.
Yes.
Okay, so,
Peel, you said, right? Not Lozanova.
Lozanova.
No, she wasn't. She had
No,
affiliation.
Lozanov.
I'm sorry.
Sorry, Lozanov was a principal in CCR. Did I miss that?
No.
Okay, thank you.
You're absolutely right. Yeah.
And Peel was an employee of CCR.
Yes.
She was not an employee of Lozanov.
Correct.
So, and the emails that we are talking about, the whole point is that they weren't for CCR business, right?
That's right.
So how couldn't CCR have a claim for conversion or trespass to chattels or breach of duty of loyalty under counts 3, 4, or 5 if it wasn't CCR's emails in the first place?
I mean, CCR suffered damages as a result of these actions through the lack of productivity and the harm that was caused to the principal. So I see my red lights on here.
It is. Thank you.
So, all right. Thank you.
Attorney Smith?
Good morning, and may it please the court. I've chosen to begin with the green light on, and happy to answer any questions.
All righty, then I'll start. You argue that your claim of a lack of proximate cause gets rid of all the claims.
That's right.
But aren't there two that have nominal damages, counts 1 and 4? So how do you respond, if you have a right to nominal damages, then don't you have a right to go forward even if you don't have any proximate damages?
Well, I would note the nominal damage issue wasn't raised in any of the briefing or below, but I still don't see how there would be any damages that are entitled, that he would be entitled to in this case. So count 1, that's with Lozanov personally, and then count 4 as to both. And I think the chief had pointed out the issue on count 4 with respect to the difference between Lozanov individually and CCR and Waywind. But even with that, there aren't any nominal damages that have been
But
requested.
technically, wouldn't he have a right to go forward and seek his nominal damages?
If nominal damages are permitted, then perhaps. But the only damages that have been alleged here are the ones that
But
began in
Justice
December.
Connor's point is that if nominal damages are permitted, then the lack of proximate cause, assuming you're correct, the lack of proximate cause to other damages does not mean that he loses as a matter of law on those counts.
No, that's true, as long as all the other requirements are met for the tort, which in this case they're not. But as far as the damages that
So if we agree with you that the elements of the torts and the breach of contract are not made here, what is the remedy? I mean, what he is alleging is this employee not only had access to these emails, but disclosed what is essentially confidential information to someone else. Whether or not the family action modification would have occurred or not, it was disclosed. Isn't that a problem?
Well, it's not a problem if one exercises due care, which in this case would have required
What do you mean?
Would have required a non-disclosure agreement, an actual non-disclosure agreement that's signed with terms to it. Another option would have been simply to not give Ms. Peel access to confidential information about Mr. Lozanov's other businesses. In his the only reason why he did that was because he didn't know how to segregate the two in his email inbox. And if this information was so confidential and so highly sensitive, that would have been a worthwhile investment. So really, it was just an issue of a failure to exercise due
Seems to
care.
me that another issue is there's nothing intrinsically private about the information that Ms. Peel apparently admittedly disclosed to Ms. Lozanova. In other words, it's not like medical records or et cetera, which, so an invasion of privacy, much less seclusion, is a stretch. I mean, there's nothing secret or private about a payment from a company for services that are required to be disclosed in court.
I agree completely, and to add to that, the other issue that's related is the filing of the cross motion to modify by Mr. Lozanov, in which he alleged to a court that his income had substantially decreased, while meanwhile he's receiving a $440,000 payment that he does not disclose in the family law proceeding until Ms. Lozanova's attorney raises, "We know about the money," and then the discovery requests are supplemented, and these very same emails are disclosed.
Is a term of employment a contract? In other words, someone says, I have this position here, you must do A, B, and C, you must not do D, E, and F. And if you accept those conditions, I will take you into employ. Has a contract been struck?
No, those are work rules and instructions to employees. In terms of the issue of contracts in employment, this court has held that you can have continued employment be consideration for a contract, but that comes up in the context of things such as non-compete agreements and things such as that nature. Really what we had here, and I think the trial court probably said it best, was that Mr. Lozanov, as Peel's boss, gave her instructions, and Ms. Peel, as an employee, agreed to follow those instructions.
Isn't that the definition of a contract? There's been a meeting of the mind, there's consideration, you have employment, I have these rules.
Well, there's not consideration and there's not an offer. It's just instruction. And if that was the rule, then a contract is formed pretty much every day that an employee comes to work and their boss asks them to, write a memo, cover the phones, whatever it is. Under that type of theory, an employee could be sued for virtually any violation of a work rule or poor performance or any number of hypothetical situations. I guess one other point I would add to, if there aren't further questions, but just something to not lose sight of, is almost all of these causes of action have a state of mind attached to them. And it was not disputed, it was in fact admitted that Ms. Peel disclosed the email to Losanova because she thought it was okay to do. That was a statement of material fact that we included that was admitted. So that right there would eliminate most of the causes of action.
Well, I mean, intent is usually something for a trier of fact, and she originally lied about whether she had disclosed this, correct?
She did, but we
Which
have a
kind of shows maybe she felt guilty after the fact.
Well, it could show any number of things, and I think in our response, we noted that she was fearful of Mr.
But isn't that the
Losanov.
point of a fact question? In other words, we certainly don't have to accept that person's statement of, I didn't mean to. If we had to accept that in every criminal case, the state would never be able to prevail.
No, but at the end of the day, the plaintiff in this case has the burden of proof to show by a preponderance of the evidence that Ms. Peel had the requisite intent. And we stated in defendant's statement of material fact number 5 that Ms. Peel shared the email with Losanova because she asked for it and she thought it was okay to do because Losanova had worked on the project, and that statement was admitted. It wasn't denied, it wasn't qualified that a jury wouldn't be required to accept that. It was admitted for summary judgment
What is your
purposes.
response to the argument that it's not clear on this record that she couldn't figure out which one was a private email until she opened it?
All right. And again, I think that goes to the burden of proof. There needed to be some proof that would establish that she would have been able to determine what are CCR emails versus what are personal or Waywind emails. And the only testimony was that the email would show what it is, but of course, to figure that out, you have to open the email. And that was something that the trial court went through, and I think one of the footnotes where it explained that distinction.
Well, when it's the seclusion cause of action, it doesn't matter about the publication. What matters is at the time of the invasion of the seclusion, correct?
Right.
So at the time of the invasion, that would be when she read the email, correct?
If you were to accept that reading the email is an invasion of privacy,
Right.
That's when the tort would be committed. There are still issues about whether there is actually a reasonable expectation of privacy in that email for any number of reasons. And then also there's the intentionality issue.
Does it matter that she was an employee of the corporation and not of him? So when he's saying, don't read my personal emails, that's really not a function of her employee duties, correct?
Well, I think that's something that actually helps him, because as her boss, he gave her access to his personal email account and said, you can use this for work purposes, and you need to go through this to look at CCR emails, but don't look at any other ones. But there was no mechanism for her to distinguish between what's CCR and what are personal.
And her duty of loyalty is to the corporation, and if there was any agreement between her and someone, it was with the corporation. So where does the duty towards him arise?
No, she doesn't have one. She doesn't have a duty to Mr. Losanov, and we would contend she doesn't have a duty to the corporation either. She's an employee, but I don't think there's any law from this court that has held that mere status as an employee gives rise to a a duty of loyalty, such as a fiduciary relationship or anything of that nature.
So if your employer person asks you to do something or not, and it's not in your agreement with your corporate employer, then how does that, is there a separate contract with the person employer?
I'm not sure I'm not.
How can, are there two contracts here? There's her contract with the corporation to do her corporate duties, correct?
Well, there's no contract.
Right,
She's
well-
an employee at will.
Yes, an agreement she has to do things in furtherance of her corporate employer. So when a personal favor is asked by one of her bosses, does that form a tort when she doesn't comply with that favor?
No, it's just a personal interaction, but there's no duties imposed on her. No
If a
legal
person adds a long list of people carbon copied on an email to a person, have they just waived their right to ever claim any privacy or confidentiality about that transmission?
I don't think that by itself necessarily means that, but it would depend on who those people are. For example, if there's evidence that these people are, it's a counselor or somebody with whom the person shares a confidential relationship,
So that would be a fact. That would be a fact question.
That would be a fact question, and there would have to be evidence offered to support that there was some confidential relationship at issue, which there isn't in this case.
There don't appear to be further questions. Thank you.
Thank you.
Attorney McLean, was there something inherently confidential about these emails, or is it just that Mr. Lozanov wanted them confidential?
Sure, the exact point that Justice Horton raised, I was going to jump up and talk about. There's no requirement that the records themselves or the documents themselves be somehow inherently confidential, like medical records or attorney-client privileged information. All of us have an expectation of privacy in our personal affairs. I mean, that's what intrusion upon seclusion has always gotten at in our case law.
Is there an argument, though, that this is business proprietary information? Maybe not trade secret, but at least proprietary?
It's certainly proprietary information, absolutely. And I mean, I think we all recognize that in the nature of business, any private, confidential business communications are important. The confidentiality of them is sort of just inherent in the fact that they're confidential business communications. I mean,
Proprietary as to who? CCR?
they would be proprietary to, well, in this case, I think CCR was damaged by the,
But they weren't CCR's communications.
they weren't, they were Waywind Communications, which my client also had an interest in. So,
How can the receipt of income that's required to be disclosed in family court be considered confidential?
well, I think our tax returns are confidential. I think our income information is confidential. Whether it's required to be disclosed in the family matter is, I think, a red herring as we analyze the legal issues here. I've said that a number of times. There are other elements of damages. I'm not sure that the money that came in was income required to be disclosed on a child support affidavit.
But the only other element of damage is really his indignity, if you will, at this happening. I mean, the
was
damages he's claiming really come from the fact that he claims that Peel provided essentially true information that he wanted to keep from the court.
Well, it's not just that. He was clearly severely affected emotionally, that had physical ramifications, and CCR was also impacted by that because of his loss of ability to function for a period of several months. And a lot of money was lost because of that. I see my red light's on. Thank you very much, Your Honor. Thanks,
Thank you,
Dennis.
counsel. Thank you, and as is our usual practice, we will be taking the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.
All right.
And you may be seated. The matter before the court is Alaf versus Shoreline Holdings 5. This is Cumberland 2413. We are being streamed. Okay, we had a little trouble with that earlier. We are being streamed live on the web, both by video and by audio. And if counsel would introduce yourselves by saying your names for the record, starting with the appellants, please.
Good morning, Your Honor. This is Jeremy Dean, and I'm here for the appellants Rob Crawford and Shoreline Holdings 5, LLC.
Please the court, Emma Hallis O'Connor, attorney for the appellees, Zachariah Alef and Stephanie Crosby.
Thank you. And Attorney Dean, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. So good morning, Your Honors, and may it please the court. I'd first just like to address the assertion made by opposing counsel that landlord did not, in this case, did not present an itemized statement of damages to the tenants. I think this is just a point that needs to be made out front, and I want to get ahead of it. He did. The Section 6033 requires a written statement itemizing the reasons for the retention of the security deposit. That was provided. I wrote the letter. It's in the record. There were two reasons: rent for January, rent for February, and they're both stated very clearly in the letter. The other side confuses the issue essentially by arguing that the landlord at that time had to present all of his potential damages, known and unknown, at that time. And that's not what it's simply not what the statute requires. It requires the landlord to itemize the reasons for retaining any portion of or the whole deposit. And that's what happened. So that issue to me is ended by the fact that that letter was sent. It was sent, and whether it was sent timely is another question, which depends on whether the lease was terminated.
And isn't that really the issue? Isn't it a fact question for the court as to whether the lease was appropriately terminated?
It's a question of fact, right? And we did not ask for a jury trial, appeal for a jury trial. So that question of fact has been decided. The problem in this case, though, is that the court, there's no basis for the decision that was made. I've highlighted all of the evidence that could possibly support that conclusion in the record, and the statements don't do it. It's all very much. We will talk about that later. There's assumptions.
But
There's no
you
meeting of the
agree
minds.
that if there is evidence from which the district court could find, the small claims court could find that he accepted and agreed that they could terminate early, then the email regarding the security deposit is untimely, and therefore its content really doesn't matter. And I understand it depends on that fact finding, but.
That would be, yes, that would be true, Your Honor. If this is a clear error standard that we're under, I believe that's what I said in my brief.
Okay.
So I'm not disputing the standard of review. I think, but we are asserting that there is no support in the record. It is insufficient to support that.
Can I
as a
go
matter
to
of law.
another issue, though? Is this really a final judgment? I mean, what you're arguing about is attorney's fees, which have not yet been awarded.
I thought of that, and so there's a footnote in the brief.
There is. It doesn't seem to address it very much.
Well, the reason I didn't put a lot of effort into that is because we had a deadline for filing the appeal. I didn't know at that time what the attorney's fees was. I could be mistaken, but I don't believe that motion had been filed yet, and the district court certainly hadn't ruled on it. So in a sense, that's
The court
true.
still hasn't ruled on it, right?
That's correct, Your Honor. But if it was 1 cent, if it's any, the court awarded attorney's fees. So any amount of attorney's fees that might be awarded over the $6,000.
So if we say, okay, well, are you saying it's final as it is because it's ancillary, or are you saying, well, the judicial economy? I'm not sure what you're saying.
I think it's fine. I think, well, there is a judicial economy argument to be made, because if this court says, well, it's not final, go back down, learn what the attorney's fees are from the court, and then come back, that would be a waste of resources of our time and the court's time.
Well, what if you have an argument? In other words, the district court, or maybe you don't argue. If the district, let me ask you that, straightforward. If the district court has the power to award attorney's fees above $6,000, and we assume that, and we find that the factual predicate is met, is there any chance you would be arguing about the amount of attorney's fees that are awarded? Or would you agree that if
I don't see it
the
plausible.
court can award the attorney's fees,
I don't at this time see a plausible argument against the attorney's fees that were claimed. They seem
In terms of the amount?
They seem reasonable to me in terms of amount.
Okay.
So I don't anticipate making that argument. I may go through
I mean,
the
you know,
merits.
you've seen the affidavit, you've seen the request, right?
Correct.
Okay.
It seems like a reasonable attorney's fees to me for what we did in that court.
Okay,
So
thank you.
I don't anticipate challenging that. I can't think of a basis for doing so right now.
Okay.
The problem is the award of attorney's fees.
I understand that you don't think that there was the power to give it at all.
Above $6,000. I mean,
Correct.
attorney's fees, like I said in my brief, if it was...
I meant above 6,000.
If it was a $2,000 judgment and there were $4,000 in attorney's fees, of course that would be reasonable. And we would not have appealed this decision on the basis of this factual claim alone, because the clear error standard in this case is just too high, right? It's too high a burden. I think that this is the only case I've ever had that has a chance of actually meeting that burden. Because I just find this record to be far too nebulous. The conversations, the discussions, everything it's assumptions, it's maybes, it's this, that. We'll talk about that later. And I believe
But can't you use the surrounding circumstances to infer the agreement? In other words, even if the phone calls or the actual conversation was more nebulous, not, yes, you can leave in this amount of time, the actions here are consistent with the landlord accepting the early surrender and early termination, aren't they?
Well, I don't see that in the record. I mean, as I recall, what my client did was come back into the apartment, start making repairs, advertise for someone. I mean,
Well,
it's
they
mitigating
were
the
there.
damages.
They didn't say anything in objection when the tenant gave 14 days notice of the day they're leaving. There was no response to that, was there?
I do not remember that fact. There may not have been.
Okay. it's
And
certainly-
the agent said something about the return of their security deposit.
Yes, because that was on the table for discussion. And if my client had been able to make repairs and find someone to move in immediately, then there would have been a security deposit to come back. I mean,
Even before the discussion about getting back to them on the security deposit, in fact, the property manager showed up on the day that they said they were going to be vacating the premises. That would suggest that there was some acknowledgement or agreement that they're moving out, would it not?
well, I think my client, the problem I have with this is that imposes a very odd burden on my client. As a landlord, he and the company have an obligation to mitigate damages. They have to move in, look at the apartment, get it ready for someone else, and find someone to move in. It's not.
But that's never going to happen immediately. So what you're saying is that if this is a breach, that the landlord knows they may be able to mitigate some, but they're never going to mitigate all of it, right? Because they're leaving if they're going to get in, paint, make repairs, even if they had a tenant as quickly as possible, there'd still be a gap in there. So you're going to keep some of that money right from the beginning.
You do, and it's possible it would be possible to say, well, some of this is going to be challenged, and I don't believe that the rental agent, the property manager, said you will receive all of your security deposits
But even if they didn't have an obligation, isn't the point, going back to your point about what are the facts from which the district court could find that
Yes.
there was an agreement to terminate early? My point was that the landlord's conduct, if you will, during that period of time, from the time of the phone call on through the time the plaintiffs vacated, was consistent with an agreement to vacate early.
Well, and I think that the behavior is also consistent with simply trying to mitigate damages and make sure that he got someone else in there so that, if possible, some security deposit could be returned and he would lose no money. I mean, I don't think it would be right for him to say, well, guess what, I'm just not going to do anything for 2 months, maybe 3, 4, and then I'm going to sue you for the rest. And there hasn't been any attempt on this side of the V to go after damages, including the additional month of March, which
Which you would
I
not be
represent.
entitled to under the finding of the district court.
Correct, under this finding, but this finding has no onward applicability. We could sue and have a full jury trial over that issue in Superior Court and have a completely another case. These are not precedent setting.
Can I ask you about the statutory jurisdictional limit on the small claims court?
Yes, Your Honor.
The statute provides that notwithstanding the total amount of a debt or contract, a small claim is limited to a debt or damage that does not exceed $6,000 exclusive of interest and costs.
Yep.
Is the attorney fee, which is provided for in Section 603, 4 sub 2, are the attorney's fees part of debt or damage for the jurisdictional statute?
I would say that they're part of damages, because we're saying debt or damages.
Don't mean to interrupt you, but
That's okay.
the damages they suffered was the non-return of their security deposit, and the double damages, obviously damages there, but attorney's fees are separated out along with court costs, the amount of the debt or damage, double damages, wrongfully withheld, together with reasonable attorney's fees and costs. They seems to be semantically separated from damage.
Well, it is in that statute, but in
Yes.
this statute, there's no mention of attorney's fees. And all of the statutes that we can point to and that are discussed in both briefs, the legislature could have said attorney's fees. Perhaps it could have used the same method that was used in the Attorney General's lawsuit and said attorney's fees are available in these types of cases, and listed some of the statutes under which you could recover attorney's fees in addition to your $6,000 damage limit. But they chose not to do that. And I think that the intent is clear. This is $6,000. It's meant to be small. There are there are fewer procedural safeguards, and the little guy is supposed to be able to go into this court and do his job. So imagine I am a lay person and I file suit for $2,000. The defendant hires Bernstein Sure. They run up a $25,000 attorney's fee bill. There I am now, not getting speedy relief for small claims, but having a huge, enormous debt that I have to then pay.
On the other hand, if you're the little guy and all you want is your deposit back, you don't have the resources to go to court unless you can get your attorney's fees.
Well, in the small claims court, you can go on your own. You can prove these same facts. And
But are you suggesting that the self-represented litigants we have do just as good a job as lawyers do
Well,
in court?
You know, no, not necessarily, but in some cases they do. I've seen people represent themselves very well in court. I mean, and the purpose of court is to get to the truth, and without all of the procedural, game playing that's available in other venues, in the small claims court, you go there, you present your facts, the truth
And
wins
so
out.
the attorney's fees are probably much lower in small claims courts, since you don't have to go through all the other shenanigans as you've
And they would be,
indicated.
and I know I'm using horrible hypos, but I'm trying to illustrate the fact that there's a danger here, and it just, to me, it is not it transgresses the purpose of the statute.
Can I be clear about your argument, counsel?
Yes, sir.
Are you arguing that attorney's fees are never awardable in a small claims action? Or are you arguing that in this case, they're not awardable because we're at the cap?
They're awardable up to the cap. So even if it was a $50 claim, then you could get attorney's fees up to $6,000 if they were available under some statute or the contract. So that's the claim. Not that they're not available. They were entitled to attorney's fees under the decision.
But it's a little bit of a strange argument, because essentially what you're, by saying that it doesn't belong in small claims to go over the $6,000, what you're saying is you have to go to civil, file a normal civil claim, which means that you could be exposed to more. And in this case, the court did actually find damages in excess of $6,000, but understood there was a cap. And attorney's fees are presumably going to be much higher. So it's sort of an odd argument for you to suggest that these should be brought in civil court, because when the tenant prevails, you're going to owe a lot more.
It would be more costly for my client under that circumstance, but the plaintiff has a choice. They make a choice in the beginning. Do I want to go for the full $10,000 I think I can get, or take $6,000 and have it be much cheaper, or be able to represent myself? That's the decision.
But there's no requirement that they represent themselves in small claims court.
No, but they could pay their attorney a much smaller amount to go to small claims court and limit their damages, or they can choose to bring it in district court or in superior court and go the whole hog. I think the point is that, and you also take it from the perspective of somebody looking at those statutes, especially a layperson, and with this being the first time I've seen in any case where this question has been raised, they have no warning that they're going to be subject to these fees. They see $6,000, they think, great, and that changes their calculus on whether they defend their claim or bring a claim.
Thank you, counsel.
Thank you.
Attorney Hallis O'Connor.
Good morning. May it please the court. I will waive my reserved time and go ahead and take questions. Thank you.
Well, I'll go right to the issue of the finality of this judgment, because the attorney's fees have not, in fact, been awarded in this case.
Your Honor, I think the fact that the judgment awards attorney's fees and directs counsel to submit a fee petition because even a single penny would result in an overall amount owed that is above $6,000. The issue has been finally decided that attorney fees are allowed beyond the $6,000 limit on damages. So I do think it's ripe for...
Does it matter that Mr. Dean essentially conceded that he wouldn't actually attack the amount if we permit them to be awarded? Does that change the finality or the equation of whether we should address this?
I don't believe so, Your Honor, because I think that the amount of attorney's fees has always been considered to be a subsequent tangential issue of judgment is final without
It may be a
determination.
tangential issue, but the award of attorney's fees is what this case is about.
It is, Your Honor,
And
but
if there
this
was a
case...
contest on the attorney's fees, that would mean there's further litigation has to take place down in the court. But by his, I wouldn't call it a concession, but his statement here today that that's not going to happen.
That's true, Your Honor.
And that's what we're looking at for the finality issue here. We don't have to be concerned about a remand or whatever for litigation of the amount of the fees. The issue before us is boiled down to that very narrow point about whether it falls within the jurisdictional limit.
That's correct.
Okay.
Thank you.
So I just want to follow up on a question that I asked opposing counsel. The statute, the small claims statute, does not reference attorney's fees specifically. It says interest and costs. Normally, we don't think of attorney's fees in the category of cost. So if we were looking at, and I know opposing counsel hasn't made this argument, but I'm just curious as to your view, if we were looking at this from the perspective of the typical American rule, where attorney's fees are not awarded unless authorized by statute or contract, how do you square that with this statute?
Your Honor, I think in that viewing of the statute, the issue of attorney's fees is silent because the statute is dealing with those elements of the case that are always present in all small claims cases. There's always a case for damages, and there's always costs that are allowable, the service fee and the filing fee. But the fact that the statute is silent on attorney's fees does not mean that attorney's fees are a type of debt or damage. That is the reading that seems most illogical because those terms are so fundamentally different.
And Section 603.4.2 does specifically authorize attorney's fees.
That's correct. It authorizes attorney's fees, and it does separate them from costs, and I think there's many examples where a fee-shifting statute lists costs and separately lists attorney's fees in
But it also separates it from the damages.
And separates it from the damages, and the context of that makes sense because it's a statute that's alerting the public to the fact that attorney's fees are available in this kind of operative statute.
Talk about, there's not a lot of evidence here that there was an agreement to terminate the tenancy early.
Given that the standard here is clear error,
It is.
and that means that there needs to be no properly admitted record evidence to support the court's finding of
But is there
facts.
any evidence that the landlord explicitly agreed?
I think that the court was able to look at all of the evidence, the conversations, the conduct in response to statements that my clients believed they were entitled to their security deposit back, the fact that there was a move-out inspection, all of that the court properly considered in its totality to find that there was an agreement. The existence of an agreement is, I think we all agree today, a factual issue, and the appellants are not arguing that there is nothing in the record about this agreement. They're arguing with the weight that the trial court gave to that evidence, and that's just not cognizable on an appeal as a matter of law.
This is almost an estoppel situation, it seems to me. In other words, the tenants notify the landlord they intend to terminate on January 4, and the landlord doesn't respond until March 7th in an email. And in the meantime, the tenants act in reliance on the lack of a response, and the agent coming on the day they move out and talking about return of the security deposit.
I would agree with that, Your Honor. I think the court was properly assessing what was the objective understanding or the objective belief of the parties. What would a reasonable person understand from that conduct?
Coupled with the conversation about early termination.
Yes, Your Honor.
There don't appear to be additional questions.
All right.
Thank you.
Thank you.
Attorney Dean, you reserve some time for rebuttal.
So can I ask why the email message from you came almost 2 months after they had actually moved out?
So my understanding of it is and what I think the record shows, the tenants moved out on January 15th, 16th, whatever it was, and then they actually reached out to the landlord to say, hey,
Where's
we've
the
left.
security
Where's our
deposit?
security deposit?
Right.
And so I responded to that. So I was not informed of any of this until that point in time. So that was my first encounter with this issue. So I wrote my letter based on the facts that I understand them, which I still believe to be the facts of the case. The point I would just like to make a few points in rebuttal. I would just say in terms of ripeness, we would not litigate even if there was a contest to the attorney's fees, which I'm saying is not going to happen because I've looked at the fee petition, I see no issue, but we would not be litigating these issues again. So obviously these issues are final and ripe for determination, because if this court agrees with my client, then there are no attorney's fees. If this court agrees with the appellees, then it's 1 cent or the full amount, whatever it is. It doesn't really matter. It's still happening. It's still over $6,000. So I think that this is final for purposes of the case we have before us. It's a final judgment. I would also just say that I think attorney's fees are a form of damages, and I think the thing is that the legislature has made a determination that in circumstances like this.
Well, they're not compensatory damages, are they?
Well, I think in a sense they are, because the legislature has determined, this is the way I would view it, that in cases like this, circumstances like this, just having to bring suit at all is a form of damage, so you get your attorney's fees back.
Civil rights, they're not compensatory damages, they're separate. Aren't they usually considered separate from either in their own sui generis, but they're not considered damages unless integral to the claim?
I believe, and I don't know if it's in my brief, but I believe I found one case where they were described as a form of damages in this state. I think it was this court, but I'm not able to cite that off the top of my head. But my point is that if you look at it and its rationale is, it's because these guys shouldn't have had to sue. The legislature's saying, hey, if the landlord does this, you shouldn't have to sue, so we're punishing them with extra damages. That's the way I see it. And I think that attorney's form is another type of damages, along with the additional deposit that is not an actual damage, but somehow that's a form of damage.
Thank you, counsel.
Thank you.
Thank you for the argument in this case. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. It's my understanding, Attorney Hallis O'Connor, that this is your first appearance in front of our court for oral argument, and our tradition is to invite counsel to come back and take the greetings of the court. May I ask, are the Meade Fellows here as well? We do. So I understand that we have with us 2 of the VLP Meade Fellows attending the oral arguments, Michaela Rice and Jamie Noor. Do I have that correctly? So welcome as well. But for our purposes, we invite counsel on the case to come back and take the greetings of the court.
All right.
And good morning, you can be seated. The matter before the court is York 24377. Michaela, is it Boland? Or, okay, versus Nicholas Belair. We are being streamed live on the web, both by audio and by video. And I would ask counsel to identify yourselves for the record together with the party you represent, starting with the appellant.
Good morning, Tyler Smith for Michaela Boland.
Good morning. Kenneth Altschuler for Nicholas Belair, the appellee.
Thank you. And counsel, if you're ready to hear if you are ready to proceed, we'd be happy to hear your argument.
Thank you. Good morning, and may it please the court. The judgment in this case should be vacated for two reasons. First, that the trial court abused its discretion in setting aside the parties' settlement agreement. And second, if not, the trial court misallocated the burden of proof with respect to marital appreciation of separate property. Starting with the settlement agreement, what's important to remember is there was no dispute on this record that a settlement agreement was in fact reached, that the elements of a contract were reached. The agreement was placed on the record, both parties testified about it, and the judge accepted the agreement as fair and equitable and told the parties that the divorce was granted. The only thing that was remaining was a ministerial act of actually signing the judgment that the parties would prepare, reflecting that agreement. And when that happened, there was no pause. Nicholas did not pause and say, wait a minute, Your Honor, before we actually have this agreement granted, we need to make sure that we get a promissory note signed and in place securing the loan from my father. The court went forward and agreed that the divorce had been granted and there was no objection. And then the subsequent event, the father not funding the settlement agreement, was a risk. And it was a risk that was obvious and it was reasonably foreseeable. It's so obvious we have an entire cause of action based on that kind of circumstance called promissory estoppel. And even apart from promissory estoppel, there are reasons that notes go unfulfilled all the time for reasons that may be intentional or reasons that may just be a consequence of life, changed financial circumstances or any number of reasons. So that was a risk that Nicholas knew about, that Michaela knew about, that the judge would have known about, and that both parties would have presumably been advised by counsel. Now, the second issue in this case deals with the allocation of the burden of proof that I know this court's very familiar with. And the case law is that a party in Michaela's position is to show that an increase has occurred, not to quantify the increase, but just to show that an increase in separate property had occurred during the marriage. And this makes sense, because the owner of the property has an evidentiary advantage that the non-owner doesn't have. The owner of the property can testify to an opinion as to the value of the property. Michaela can't do that. She can seek all the discovery in the world, but only Nicholas could take the stand and say, in my opinion, this is the value of the property. So by enacting a rule where this burden is placed on someone in Michaela's position, the incentive for somebody such as Nick would basically be one of willful ignorance. Perhaps
Counsel, I see that the green light is on. Can we go to the divorce agreement as put on the record originally? I think that Mr. Altschuler has argued that essentially the promissory note from Roland Belair, from the father, was a condition precedent, and because that failed, the agreement fails.
Well, no, condition precedent is a doctrine that deals with performance and whether a person's duty to perform has been triggered under a contract. This is an issue of contract formation.
Well,
And
except that I will say that it was put on the record, page 23 of the transcript, that there was going to be a promissory note signed by Roland Belair that in the terms of that promissory note. So if that's not part of the agreement that was a condition precedent to the payment of the $50,000 a year for 5 years, why was that even put on the record?
Well, I would suggest that the reason is simply to memorialize this, because this was an agreement or a promise from Roland, and by putting it on the record, Attorney Altshuler was memorializing in a court record that this agreement did in fact happen.
And it's your view that it was to pay $50,000, that Mr. Belair was to pay $50,000 a year without regard to whether that promissory note was signed.
That's correct.
Was his ability to pay litigated?
In the motion to enforce, or on the motion to enforce settlement agreement, that was their position, that he would have had no ability to pay that. But the way that this issue should have been dealt with is, in our view, the court should have granted the motion to enforce the settlement agreement, and if there was a failure to pay the $50,000, then that's dealt with in the same way any other failure to perform under a judgment is handled, with a motion to enforce or a motion to for contempt. And at that hearing, Nicholas could have argued that he lacked the ability, lacked the financial resources, and the court would have to make a determination. The remedy is not to just simply undo the judgment. I mean, if that's the determination, then anytime you have a divorce settlement agreement, if subsequent events render performance impractical, you don't deal with that through a motion to enforce or motion for contempt. You just undo the agreement, and then you have to go back to trial.
But the parties came to the settlement discussions all with an assumption, the plaintiff, defendant, and the court. This was integral to what the settlement was, that assumption. And when that assumption immediately proved to be unfounded, not going to work, doesn't that have a retroactive effect that would be the practical equivalent of a mistake of fact rolling into that settlement?
I disagree, and I disagree with the suggestion that the assumption was unfounded, because at the time, Roland did intend to issue the promissory note. It was a subsequent event in which he basically changed his mind. So at the time the agreement was placed on the record and everyone agreed to it, everyone had a correct understanding of the facts as they existed at that time. There was going to be a promissory note, and that is what Nicholas was going to use. It was only a subsequent event that changed things, and pursuant to some
If
of
we
the law
agree
that
with your position on that issue and on the settlement agreement issue, do we need to reach the question of the property burden of proof?
No, the only other remaining issue that would remain for the trial court is, obviously a lot of time has passed between the time when the settlement was placed on the record and the point where we are now. So I think the trial court would have the authority to at least consider matters such as attorney fees, and basically trying to roll the clock back to when the settlement agreement should have been accepted. But to answer your question more directly, no, you don't have to consider the property issue if you agree.
Counsel, on the
settlement.
burden of proof question, you said that your client had the burden to show an increase, but not an amount.
Correct.
Two questions. That's sort of at odds with Miliano and Violet, first of all. And second, how do you show an increase without showing any amount?
Okay. Well, starting with the first point, Miliano I think what Miliano is saying is that in most cases, showing the value of the increase is going to be necessary to show that an increase occurred, because that's how you normally would do it. You would say, date of the marriage, it was worth X. Date of the divorce, it was worth Y. Y is greater than X. But I don't read Miliano as imposing a hard and fast rule that is the only way of showing an increase.
It says determinable amount.
Right, but then Warren also says that the non-owning spouse must simply show an increase. And when you read the discussion in Judge Levy's treatise at 7.6e, That language all suggests that it's actually the owner's spouse who has the burden to quantify.
How
Let's
do
go
you
back
show an
just-
increase without showing an amount? What's the fact that you
Well,
put into evidence?
I would point to this case, because even though the increase was not quantified, Nicholas, the owner, testified that it was likely that there was an increase. The expert for Nicholas said he agreed that it was obvious that there was some kind of an increase. On Nicholas's CV, he boasted that he increased the revenue of residential holdings by 93%. He boasted about the increase in the number of units. So although there wasn't evidence that established or was found persuasive by the court to quantify the actual increase, the evidence was overwhelming and was clear that an increase occurred.
But the court went further. The court said, in short, there are simply too many variables for the court to determine the marital increase of residential holdings, if any, with any degree of specificity or certainty. Some or all of the other 10 properties may have decreased in value. Based on the evidence presented, the court simply doesn't know. So even before we get to the issue of burden of proof, isn't the problem here is the court was not persuaded that there in fact was any increase? Is that holding, are you suggesting that that holding cannot stand?
Yes, we're suggesting that that's a clearly erroneous finding. As I read
Can I just, in the short time you have remaining, I want to take you back to Miliano for a second, which I have a passing familiarity with. If what you're saying is correct, that all that the proponent of a marital component as a result of an increase in value, and they prove it just saying generically, well, this, time has passed, but he's put this effort into it. We have a marital, thank you very much, and they sit down. The other side says, thank you very much, we sit down. Judge says, yes, there's been an increase in the marital component, and I will impose $25,000. We would flip that in a moment because there's nothing in the record that would allow us to get to that figure. Are you suggesting that with no credible evidence regarding the amount of the increase, that the judge can go ahead and do something? You've got a minute left.
No, I'm not saying that the judge could simply pick out a value. I think that's a situation where the judge would potentially need to reopen the record for more evidence. And the reason why I
But
think
both parties have rested. The case is closed. They're not going to. They don't have any more evidence to offer.
Right, but the judge has a duty to set apart marital property from non-marital property, apart from what the parties offer. It's a statutory duty of the
But don't you
court.
then, the statute also tells you how to resolve that in terms of whose burden it is.
Well, the case law doesn't say whose burden it is on the quantification aspect of it. It's silent as to that. But when you look at Miliano, it makes this point. It says that the court can't arbitrarily set aside marital property as separate property or vice versa. And if, in effect, that's what you're doing if you impose a burden on the non-owner to quantify, at least in the context of this case.
Thank you, counsel.
Thank you.
Attorney Al Schuler.
Good morning, Judge. May it please the court. I want to quote one line from Miliano. The amount of the increase in value is an essential element of the proof. Right on point. It's part of the proof, element of proof. And I do want to point out one other thing, and I'm not going to use my whole 3 minutes. I think the appendix shows that I was the second attorney in the case. When I came in the case, the trial was actually scheduled for the next week. It was put off a number of months because of that. I filed with my entry of appearance a motion to reopen discovery. And I asked the court to allow me to appraise, excuse me, the other 10 properties. Because I found that the evaluation that was done by Mr. Phil was faulty. But I didn't know what the court was going to do. The court could theoretically order the sale of property, which my client couldn't do because he didn't own it. That motion was opposed by Mr. Libby and denied by the court, which is the court's discretion. I recognize the fact that I've said ad nauseum that the only way to show increase in value is an appraisal at the time of the marriage, time you start working, and the time of the divorce. And I saw that wasn't done. My predecessor attorney representing Ms. Miller didn't do that. But to say there was a tactical error on our part purposely done is not true. I tried to remedy what was done incorrectly, in my opinion, by Mr. Libby. I think it's his client's burden of proof. But I was willing to remedy it, and that was objected to. I'm open to any questions you may have, Judge.
So you weren't quite as clever as we were thinking you were.
Correct. Thank you, Judge.
All right. In this case, the settlement agreement was put aside on the basis of a mistake in fact. But we have clearly said that a mutual mistake of fact to undermine the validity of a contract must exist at the time of the entry, and events that happen afterwards, even if not contemplated, are not a mistake rendering a contract unenforceable. Isn't that what happened here?
No, because first of all, one of the arguments made is that everybody knew that the loan may not happen. That's not true.
Well, whether they knew or not, my point is here, it says even if, was not contemplated at the time of execution.
I would argue that if the evidence had shown that Nick could still perform without his father's loan, I think the court would have enforced the agreement. The problem is at the testimonial hearing, it was clear that Mr. Belair, my client, had no ability to pay $250,000 at all. So it was not just a mistake of fact, it was also an impossibility of performance, which is one of the things I argued to Judge Driscoll, Judge Tice, when he had that hearing at that point.
But on a motion to enforce, couldn't the court have converted the obligation into a payment over time or something of that nature, in the same way that on a motion to enforce, the court will convert an ambiguous visitation schedule into specific dates, et cetera?
I think the judge could have done that. I still think that Judge Tice made a determination that my client could not perform $250,000.
But if somebody cannot perform after the fact, how does that void the formation of the contract in the first place? In other words, at the time the agreement was made and it was put on the record, there was no reason to think he couldn't perform. He could, and he was offering to perform. And it was only after the fact, when Dad, for whatever reason, reneged on giving him the money, although it's hard for me to imagine why he can't raise the money, that it became an impossibility, in your view, of performance. But that goes to enforcement, not formation.
But it's not that he couldn't perform, it's that his performance was conditioned on his father's promise.
But that wasn't said on the record.
Oh, when we put it on the record, I think it was put on the record that he was borrowing the money from his father.
It was put on the record that he was going to borrow the money, but there was nothing in there that it was conditioned on that.
Well, I would say that if you look at the proposal made by Mr. Libby about the promissory note and what he wanted and all that kind of thing, it's very clear that this was totally dependent on Roland Belair providing his son with the money. There's no doubt about that.
How is that different than a spousal support obligation being dependent on somebody staying employed?
Well, because that's up to the person to stay employed. So if
Not always.
If the person gets terminated?
Well, if an obligor of alimony, spousal support, loses his job, then he comes back to court to modify because he can no longer meet his requirements. But this is not Nick not wanting to pay what he agreed to pay. It's Nick not having the ability to pay from the beginning. So it's not anything he did to cause it to not be able to be.
You said from the beginning. In the beginning, he did have the ability to pay, because at that point there was the representation by the father to pay it. So at that point he did have the ability to pay. Circumstances that occurred afterwards that lend him arguably not having the ability to pay. But
ability to pay is tricky because his ability to pay was his father paying it.
Right.
Nick was never going to pay it. His father was going to pay it.
So there was a change of circumstances here.
Correct.
Okay.
But that's after the fact. That doesn't void the agreement.
My argument with Judge Tice was impossibility to perform.
Oh, we understand that was your argument.
Right. So Judge Tice found it was also a change in circumstances and a mistake of fact. And I do think
it wasn't a mistake of fact. At the time they entered into the agreement, there was testimony when Mr. Boland actually showed up for the motion to testify at the motion to enforce. He said, yeah, at the time that they were engaged in those settlement discussions, I was agreeing to put up the promissory note. I changed my mind the day after. That's a subsequent event.
Right, but Nick's agreement to pay was conditioned upon his father's agreement, and when his father's agreement,
But it may have been conditioned in his mind, but that is not what was put on the record as part of the divorce judgment. The divorce judgment was, I will pay X amount. This is how I plan to finance it, but I will pay X amount.
But the fact that Mr. Libby requested and required and demanded a promissory note by Mr. Belair, he didn't request one of Nick. He requested it of his father because he knew my client had no ability to pay it. So by him inserting that condition into the divorce judgment, it became part of the agreement itself.
Well, of course, none of that is on the record either, those negotiations.
True, but the court can certainly infer from the fact that that was a requirement of the judgment. There's no promissory note by Nick required in this divorce judgment. The promissory note is required of Roland. So he was made part
Over
of this
whom the
agreement.
court has no jurisdiction.
Correct. Exactly.
And so how could that be part of the divorce judgment?
Because that was part of the agreement.
Yes, but how can the court order somebody to do something that over whom he has no we have no
The court can't. And so that's why without an agreement between the parties, the court could not order, Judge Tice or Judge Driscoll could not say, I order your father to provide the funds to do this, or to enforce his father to do this, because he's not part of the proceeding.
Wouldn't events that occurred after the fact be properly addressed by the court addressing the circumstances that occurred after the fact?
In what way, Judge?
Motion to modify the judgment, motion to deny enforcement proceedings, and there's a whole flurry
You
of
can't modify the
possibilities.
property settlement, so we can't modify that. So the judge, so there was no way to remedy the $250,000 requirement because Nick couldn't pay it and his father refused to. So no modification would work.
Well, if Nick can't pay it, he's not going to be held in contempt of court if there's not, because the burden's on the other party to prove it.
True.
So he's
So in
covered on
effect-
that. But if he develops the ability to pay at some point down the road, then the original words, payments Nicholas to Michaela, $50,000 per year for 5 years, may come back to life again.
That's true.
Because that's what they promised.
But you're also inviting a lifetime of litigation over that provision, which may be appropriate, because until or unless he's able to pay it himself, it's unenforceable. I do believe a judge.
But as you know, under contempt law, it's not the ability to pay all. The ability to pay is not an all or nothing proposition. It is the best of the ability. In other words, even if he can't pay all of $50,000, if a contempt is brought, is there some ability to pay some? And
Correct.
so, it may be that she is left without the remedy that she wants, but that's the remedy she gets.
But so you're right. That's correct. The judge could say you can afford $5,000. Absolutely could do that. But you're still inviting litigation for the rest of these people's lives because he's not going to pay $250,000 in 5 years or 10 years or 15 years. Probably if and when his father passes away, and if and when he inherits something, he'd have the ability to pay. But that's speculative. We don't know when that's going to happen or if that would even happen. He could write him out of the will. So we don't know.
Let me turn to the finding that I asked Attorney Smith about when the court said there are too many variables for the court to determine marital increase, if any. That may take it, essentially, the court said, I can't, and said the court simply doesn't know whether, in fact, it's increased in value at all. I think the argument from Attorney Smith is, given Mr. Belair's testimony, given the testimony, I think his name was Perry, of his expert, even if there's not a quantifiable amount, everyone agrees there is some increase in value. Is that finding sustainable, that there's no increase, that I don't know if there's an increase in value at all?
The judge could certainly have decided based upon the evidence that there was an increase in value because Mr. Belair said there was an increase in value. I agree with that.
But the judge basically said I can't say that there is an increase in value.
Well, my interpretation was saying because I don't know what it is, I can't find that there is any. I mean, Nick's saying, yeah, I think it went up in value, and Mr. Perry's saying, yeah, I think it went up in value. Thinking doesn't matter.
Well, I guess what I'm kind of getting at is if the judge is saying, I am not persuaded that there may be an increase in value, but I'm not persuaded with any degree of specificity or certainty that there's any increase in value. I simply don't know because some of the other properties may have decreased. Is that enough to take it out of the issue of burden of proof?
I think
of the quantifiable amount that we've been all talking about.
Right. I don't think you ever take the quantifiable amount out of the burden of proof. I don't think you can. I think you have to know the value at the time that the marital interest is triggered until the marital interest ends. You've got to know what that is. And I think the court's very appropriate to say who has that burden of proof.
I think the
Miliano
question-
says who has that burden
The
of proof.
question is, if the judge found that it wasn't clear that there was any increase, does that mean that Ms. Boland failed to meet the burden that even she agrees she had?
Yes, I do
to
believe so.
demonstrate that there was some increase?
Correct. I think so. That'd be my view. And I understand that the words, if any, may not be artful, but my interpretation was Judge Driscoll was saying, it's not quantified, so how do I know there was an increase no matter what? I mean, judges can reject
I think
expert
now it sounds like you're
testimony.
backing up from what I thought you just conceded, but.
Well, no, I think it's a factor, but we also have expert testimony that we give to judges, and judges don't agree with either expert. So even if everybody says there's been an increase, Judge Driscoll has the right to say.
Let me try and say it another way. I think that what Mr. Smith is arguing is that given the state of the evidence, the judge has to agree that there was some increase, even if he's not sure of the amount. And if that is the case, that their position would be they met their burden, it's now up to you to show how much of it was not marital. And that, so it poses the issue of the burden of proof. But my question is a finding, if we interpret it that way by the judge, that he's not persuaded by a preponderance that there is, in fact, an increase in value, doesn't that just take it away right there? That means that no matter how we articulate the wife's burden of proof in this case, it wasn't met.
Yeah, I agree with that summary.
I thought
agree.
you might. I thought you were starting not to agree with that.
No, I think you said it spot on. You said it much more artfully than I did.
There don't appear to be additional questions.
Thank you.
And Attorney Smith, you reserve some time for rebuttal.
You've actually, I want to jump on your 3 minutes just for a quick question coming
Sure.
through the door. If we accept your argument that the agreement is valid, binding, and it was error for the court to reject it, this gets kicked back to the court, the agreement is in place, and then the matter would proceed to further hearing, I assume, for the other issues to resolve the case, support and things like that. Knowing,
That was all.
I mean, at that point, she has this order for $50,000 a year that we know may not, and then the court would make that assumption. Might your client end up with a smaller result in her favor because the court is assuming this $50,000 per year thing coming through the door? I'm just looking down the road trying to see what this is going to look like.
Yeah, it's certainly possible if you remand and direct the court to accept the agreement, it's put in place, then Nick doesn't pay it, and then we get into a motion to enforce. Any number of things can happen.
But doesn't that reset the entire analysis for the district court? I mean, if they start with the assumption that this settlement is there, is the court going to tinker further with issues of support and property division? And
I thought the settlement was a complete settlement of all issues in the divorce, if accepted.
It was. The issue, as I see it, is if you remand, the date of the final divorce judgment should be dated to the date on which the agreement should be accepted, and the
okay,
reason
so
for
you're saying
that is so.
It doesn't open the door for the court to fiddle further with the.
No, but
Okay,
I would say, for example, Michaela could file a motion to modify if, for example, she
Okay.
were to say that Nick's income went up.
And the motion to modify would be cued to when they put it on the record, really, and as when it should have been accepted as opposed to 2025.
Exactly.
And that
The
would be
only
a
other
separate proceeding.
The only other area of tinkering, so to speak, in my view, would be the issue of attorney
Okay,
fees and litigation
that's all my
costs in the
question was.
meantime.
How does the divorce judgment as a whole that was agreed upon at the settlement and put on the record compare with the ultimate divorce judgment that was issued? In other words, on all the other issues, are they basically in agreement? except for this?
They're not, well, the biggest difference is that the final judgment has a spousal support component, which the stipulated agreement did not.
So that would be removed.
So that would be removed. But there would be the property distribution of the sum total of the $250,000 that Nick would be responsible for. And if there aren't any further questions, I'd rest on our briefs.
Thank you.
Thank you.
And thank you, counsel, for your argument. As is our usual practice, we'll be taking the matter under advisement and issuing a decision in due course. And with that, we're in recess for the morning.